Chapter 47. Suits for Reimbursement, Contribution, Exoneration, and Subrogation. Analysis. Section 911. In general, under the early jurisdiction at law, in the absence of express contracts for indemnity or exoneration, it was left to the caprice of the creditor to determine upon which of several parties bound for the same obligation the burden should fall, the loss being left wherever the creditor, by his choice of a defendant, might put it. This inadequacy of remedy on the part of the victim, and consequent failure of justice, became, however, a ground for the interposition of equity, and the proper readjustment of such burdens was, at an early day, an important field of equitable jurisdiction. The efforts of courts of equity have been directed toward placing the loss, as far as possible, on the parties ultimately liable, or as between two or more not ultimately liable, on the party whose liability is prior, and, as between parties equally liable, toward distributing the loss equally among them. The former result is reached by an action for reimbursement, and the latter by an action for contribution. Both of these results are assisted by the action for exoneration, and the remedial process of subrogation. Section 912. Reimbursement. Parties entitled thereto, when a party only subsequently liable for an obligation, performs any part of it, he is entitled in equity to be reimbursed or indemnified to the amount of his loss, by any other party to the obligation whose liability is prior to his own. This right is given not only to the strict surety and to one who mortgages property to secure debt of another, but to a guarantor, a sub-surety, suing the principal debtor, or a party not a strict surety, but merely secondarily liable for the debt, even ex delicto, in certain cases. And a party appearing on the face of the obligation as principal may prove himself or surety by parole. It is held in many cases, however, that the obligation must have been incurred at the request of the principal debtor. A mere stranger or volunteer paying the debt of another without request or subsequent ratification is not entitled to indemnity from the latter. Section 913. Conditions of recovery. The action being for reimbursement, some payment must first have been made by the plaintiff. It may, however, have been only a partial payment. The debt may be paid before it is due, but there can be no recovery from the principal debtor, of course, until his obligation to the creditor has matured. A cash payment is not necessary, provided there be a total or partial satisfaction of the obligation, at the surety's expense. If payment has been exacted from his property, that is sufficient. So if he has given his note, which the creditor has accepted in satisfaction, the surety party need not actually have been sued, but he must have been under at least a prima facie liability to pay, and have made the payment in ignorance of any valid and meritorious defense. Section 914. Amount of recovery. Incidents of right. The action being for reimbursement, the surety can recover only what he has actually paid out, even though he has thereby compromised and satisfied a debt of a larger amount. Costs reasonably incurred in the defense of an action brought by the creditor are regarded as part of the damages for which the surety is entitled to compensation. The right to sue for actual reimbursement does not arise until some payment has been made by the surety, and the period of limitation for each payment begins to run when the payment is made, provided the obligation is then due. And as the action is based on an implied promise, the period applying to such actions governs. So, also, the fact that the principal debtor has received a discharge in bankruptcy is no defense to an action by the surety for reimbursement, on account of a payment made after the discharge, at least where the bankruptcy statute makes no provision for proof, by sureties, of their contingent claims. But while the right to reimbursement does not arise until payment by the surety, he is nevertheless, for some purposes, regarded as a creditor from the time he first became bound as a surety, and so can set aside a fraudulent conveyance or homestead made between that time and the time of payment. Section 915. Contribution, Statement of Doctrine. Jurisdiction in equity. When there are two or more parties bound in the same degree by a common burden, equity demands, as between themselves, that each shall discharge a proportionate share, and when one of such parties has actually paid or satisfied more than his fair share of the burden, he is entitled to a contribution from each and all of the others similarly bound, in order to reimburse him for the excess paid over his share, and thus to equalize their common burden. This right to contribution, after payment, while originally a matter for the exclusive cognizance of courts of equity, was long ago adopted and enforced by courts of law, but the equitable action still remains, and in some cases, has distinct advantages. The legal action, except under the reformed procedure, would seem to be confined to a separate suit against each surety, for an aliquot part of the loss. And in most jurisdictions, the recovery at law seems to be confined to a sum based upon the whole number of sureties originally liable, while in equity it is based upon the number of solvent sureties within the jurisdiction of the court. In the equitable action, the principal and all co-sureties may be joined, and as full indemnity as possible obtained from the principal, the balance of the debt being distributed equally among the solvent sureties. Section 916. Parties entitled to contribution. The most conspicuous and numerous examples of contribution arise in cases where one of two or more co-sureties, having discharged more than his fair share of the debt or obligation, is held entitled to contribution from the rest. In these cases, the parties must be true co-sureties, liable in the same degree, and not one liable subsequently to, or as surety for, another. But this being so, it is immaterial that their liability depends upon different instruments, or arose at different times, or exists for different amounts, so long as they are sureties for the same debt or obligation of the same principal debtor. It has been held that parties who have become bound without their consent, and through the fraud of a common agent, are nevertheless entitled to contribution among themselves. And where the suretyship obligation is imposed by operation of law, as in the case of individual liability of corporate stockholders, the rule is the same. The right to contribution exists also among joint principal debtors, where one has paid more than his just proportion of the principal debt. So, with joint co-contractors of any sort, whether the principal obligation call for the payment of money or the performance of an act, one who performs the act, or discharges more than his fair share of the expense, is entitled to recover the excess from the others. In the case of joint tortfeasors, equity ordinarily leaves the burden of compensation for the wrong wherever it may happen to be, as no one will be permitted to show his own wrong, in asking assistance of equity, but where several are jointly responsible for an act not necessarily nor ordinarily unlawful, one who acted without moral guilt or wrongful intent in the commission of the act, and who has paid the damages caused thereby, may recover contribution from the other wrongdoers. Joint or joint and several liability is of the essence in the cases mentioned above, and where a number of parties are each severally bound for a specific portion of a debt, either as principals or as sureties, and one pays more than he was bound for, he is entitled to no contribution from the others for such excess. As among themselves, each party is considered a principal debtor for his own share of the obligation, and a surety for the remainder. The doctrine of contribution is also applied in cases where an encumbrance, binding several pieces of property equally, is paid off by the owner of one of them. In these cases, aside from any right of contribution arising from the personnel liability of the parties, under the doctrine as already stated, the party making the payment is entitled to a lien upon the property of the others, to secure contribution from the latter for their share of the expense. Here, as in cases of personnel liability, however, the various properties must be liable in the same degree, and, there being no personal liability to a common creditor, there should be none to the party discharging the encumbrance, and the latter, in enforcing contribution, should be confined to rights against the property itself. The right of one of two co-tenants who has made necessary repairs, to contribution from the other, is recognized in equity. Section 917. Conditions under which equitable action is maintainable. No right to reimbursement arises until one party has discharged more than his proportion of the common obligation, even though his co debtor has paid nothing. This discharge may have been effected either by a cash payment, or in some other way, as by a new note. And it is not necessary that the payment should have been made under actual compulsion, or that the party making the payment should actually have been sued. There must, however, have been an actual liability to pay, on the part of the person making the payment. The other parties, however, may be compelled to contribute, even though, as against the original creditor, they would have a valid defense. Like every other party seeking the assistance of equity, a party seeking contribution must himself do equity, and any showing of bad faith, or negligence on the part of the person making the payment will defeat his right to contribution from the others. In cases of co-suretyship, as a further condition to recovery, some courts insist that the party asking contribution shall first exhaust his remedies against the principal debtor, or show that the latter is insolvent. This is considered unnecessary, however, in most states. Section 918. Amount of recovery, incidents of the right. A party who has made a partial payment is not entitled to contribution, even though the others have paid nothing, until his own payment exceeds his proportionate share of the whole debt, and he is then entitled to collect a proportionate share only of the excess, from each party, the proportionate share in each case being determined by dividing the total sum in question among the number of solvent parties within the jurisdiction of the court. Whether a party is also entitled to contribution for reasonable costs spent in defending a suit, is a matter upon which authorities disagree. When there are several distinct obligations with different penalties, to secure same act, contribution between the different sureties is in proportion to the amount of the obligations signed by them, respectively. The right to a cash recovery arises when one party makes his first payment in excess of his fair proportion, and the statute of limitations, accordingly, runs from that time. The action is considered as based upon an implied contract, and the period of limitation applying to actions of this nature governs. And since the liability to contribute is not complete until this payment, it follows that a discharge of one party, in bankruptcy, before payment by the other, is no defense to an action for contribution. The right to contribution is assignable. Section 919. Exoneration. One who is bound by an obligation upon which another is primarily liable, may, if the obligation becomes due and remains unpaid, bring an action in equity, to compel the principal debtor to pay, and the creditor to receive payment of the obligation, and thus to exonerate the party suing from his liability, and protect him from the unnecessary withdrawal of capital involved in making payment and suing for reimbursement. And one who, without assuming any personal liability, has mortgaged property for the security of another's debt, may likewise maintain an action to compel the principal debtor to exonerate his property. And since several co-sureties, as among themselves, are considered each as principal debtor for his own share, and as surety for the others, it is held that a surety, against whom judgment has been obtained for the full amount, but who has, as yet, paid nothing, may compel his co-sureties to contribute their shares, and so to exonerate him from a liability to that extent. The inadequacy of the remedy at law, in failing to provide compensation for damages which may be caused by even a temporary withdrawal of a large amount of capital, seems to be the basis of this action, and should, it is submitted, permit of a similar action by any party to an obligation, against another whose liability is equal with, or prior to his own. The language of the court and cases cited in Woolmer-Shanson v. Gulick would seem to bear this out. Similarly, if a mortgage has been given to a party subsequently liable for his indemnity, he may, even before payment, secure a foreclosure of the mortgage, and application of the proceeds to the payment of the principal debt. Since this is an action to compel payment to be made, not to the surety himself, but to the creditor, the latter must be made a party. Otherwise the decree can be only conditional. Section 920. Subrogation. When an obligation is discharged by one not primarily liable for it, but who believes himself to be acting either in performance of a legal duty, or for the protection of a legal right, or at the request of the party ultimately bound, and even in certain other cases, favored by public policy, where none of the above circumstances may be present, the party thus discharging the obligation is entitled in equity to demand, for his reimbursement, and subject to any superior equities, the performance of the original obligation, and the application thereto of all securities and collateral rights held by the creditor. The same equity which seeks to prevent the unearned enrichment of one party, at the expense of another, by actions for reimbursement, contribution, and exoneration, operates here, by creating a relation somewhat analogous to a constructive trust, in favor of the subrogee. or party making the payment, in all legal rights held by the creditor, and the subrogee may proceed to enforce the trust. Section 921. Parties entitled to subrogation, payment of the debt of another, as by a mere volunteer, will not, of itself, entitle the party making the payment to subrogation. Equity will relieve, in general, only those who could not well have relieved themselves, and these may be divided roughly into the three classes already suggested, that is, first, those who act in performance of a legal duty, arising either by express agreement or by operation of law; second, those who act under the necessity of self-protection; third, those who act at the request of the debtor, directly or indirectly, or upon invitation of the public, and whose payments are favored by public policy. Whenever a party discharges an obligation in performance of a legal duty, that is, an obligation for the performance of which he was legally bound, but for which his liability was subsequent to that of another party, he is entitled to be subrogated to, and to have the benefit of, all rights of the creditor and all securities which may at any time have been put into the creditor's hands by a party whose liability is prior to his own, on which the creditor may have obtained from such party. The most conspicuous example of this class is the ordinary surety on an obligation for the payment of money, who has become such at the request of the principal debtor. Such a party is entitled to subrogation, though he appear on the principal obligation, not as a surety, but as a joint maker with the principal, and apparently himself a principal, although he be bound by a separate instrument. And one who becomes surety, not on an obligation to pay a certain sum, but on a penal obligation, conditioned on the performance of some act by the principal, may likewise become entitled to subrogation. And all this is true, not only of a surety for the principal debtor, but of one who, as surety for, or indemnitor of a surety, is compelled to pay the obligation of the principal debtor. It seems immaterial, moreover, whether or not the debtor has requested, or consented to, the assumption of the surety's obligation, and the latter may be entitled to subrogation though he assumed his obligation without the knowledge, or even against the will, of the principal debtor. Nor is it material whether the principal obligation arises ex contractu or ex delicto. Thus, one responsible, by bond, for a breach of trust or neglect of duty of another, may be entitled to subrogation. And a fire insurance company bound by its policy to make good a loss caused by fire resulting from the negligence of a third party stands in the position of a surety for the latter, and, upon payment, is entitled to subrogation to the rights of the insured against such party. Coming also within the class of payments made in performance of legal duty are payments made by parties whose obligation is imposed, not directly by contract, but by operation of law. Payments by a stock holder in discharge of an individual liability for corporate debts, or by a partner for debts of the firm, are within this class, and in both cases, the party making the payment is entitled to subrogation. Other cases where the liability of a party making a payment is considered subsequent to that of some other party to the obligation, and in which, therefore, the former is entitled to subrogation, are cases of payment of more than his fair share by one of several joint debtors or co-sureties. In these cases, each party is considered, as against the others, as primarily liable for his own proportionate share of the obligation, and as subsequently liable for the shares of the others. And similarly, where a mortgage debtor assigns the mortgaged property to one who assumes the debt, the liability of the former, though originally primary, is considered as subsequent to that of the assignee, and the former is entitled to subrogation against the latter. It would seem that in the classes of cases above treated, it is sufficient that the payment be made in performance of a supposed legal duty, and in good faith, even though the party making the payment were not really bound. The second class of parties entitled to subrogation consists of those who, while not legally bound to pay, yet might suffer loss if the obligation is not discharged, and so pay the debt in self-protection. In this class are included subsequent encumbrances paying off a prior encumbrance, and owners of property, or of equities or partial interests therein, paying off prior encumbrances. It would seem here, as in the first class of cases, that one acting in good faith in making his payment, and under a reasonable belief that it is necessary to his protection, is entitled to subrogation, even though it turns out that he had no interest to protect. Cases coming third in the classification suggested above are those in which payment is made by a stranger to the obligation, acting neither under compulsion nor for self-protection, but at the request of some party liable for the debt. In these cases, perhaps upon the ground of an implied promise, the party making the payment is usually held subrogated to the rights of him who is paid. Whether one not himself paying the debt, but loaning money to the debtor upon his personal security, but with the understanding that it is to be used in removing an encumbrance, is thereby entitled to claim the benefit of the encumbrance removed, is a matter of doubt. Persons who attempt, in good faith, to purchase property at a void judicial sale, and whose purchase money is used to satisfy valid claims against the property, while they act neither by compulsion nor request of the debtor, nor for self-protection, are nevertheless warranted in their payment by public invitation, and are held subrogated to the rights of the parties receiving the money. The same rule has been applied in the case of a void sale by a mortgagee under a power. A mere volunteer, it is generally agreed, is never entitled to subrogation. The term is used to designate one who, acting upon his own initiative, pays the debt of another without invitation, compulsion, or the necessity of self-protection. Section 922. Nature of the right _purely equitable. The process of subrogation is analogous to the creation of a constructive trust, the creditor being compelled to hold his rights against the principal debtor, and his securities, in trust for the subrogee. And even where the creditor held an obligation for which the subrogee was jointly bound, so that his payment constituted at law an absolute discharge by performance, so that there was really nothing to hold in trust, equity, by a doctrine somewhat analogous to the principle of estoppel, treats the debt as being still in force, for the benefit of the subrogee. Other courts, adhering more closely to the rules of constructive trusts, refuse subrogation in cases of the latter sort, unless the payment is made in the form of a fictitious purchase by a third party, who will hold the claim in trust for the subrogee. And the surety is allowed to bring a bill in such states to compel the creditor, upon payment of the debt, to make such an assignment. Subrogation is purely an equitable right, and being an equity, it is subject to the rules governing equities. The subrogee can work out his rights only through the creditor, and consequently his rights are limited by those of the creditor, and he can enforce no rights that the creditor could not enforce. This equity in the creditor's securities is cut off by an innocent purchase of the latter for value. It is subject to prior equities, as well of the creditor as of third parties. It will, however, prevail over equities arising subsequently, or over a purchaser with notice of it, as between several parties to an obligation who are not ultimately liable for its payment. The equity of anyone paying the obligation is, of course, superior to that of parties whose liability is prior to his own, but subject to the equities of those whose liability is subsequent to his own. Like any other person seeking equitable relief, the subrogee must come into court with clean hands, and one making a payment in order to defraud another will not be entitled to subrogation. A payment, at the request of the debtor, under a contract void for usury will not support a claim for subrogation. Laches may defeat the right of the subrogee, but this seems to be so only where a third party has thereby been led to act to his disadvantage. Section 923. Conditions upon which subrogation is allowed. Payment other security. In the case of a suretyship obligation, a limited equity of the surety in the rights of the creditor against the principal debtor arises as soon as the obligation is assumed, without further condition, and if any of these rights are thereafter released, to the prejudice of the surety, he is released from his obligation. But the right of a subrogee to have the principal obligation and its securities actually applied for his own benefit does not arise until the creditor has been paid in full, or at least until the principal obligation has been discharged in some way. And where a collateral security was given, in the first place, to secure other debts, as well as that by which the subrogee was bound, these, too, must be satisfied before the subrogee may share in the collateral. A payment made with the intention of conferring a gratuitous favor on the principal debtor will not give rise to subrogation, but the presumption is against such an intention as this. It has been held that a party seeking subrogation must show that it is necessary to his protection, and that there is no other way in which he can get reimbursement, and that one who has other security is therefore not entitled to subrogation. Other decisions recognize the latter part of the rule, but place it upon the ground that by an express contract for indemnity, the surety has waived subrogation. It is not necessary that the subrogee, either at the time he first became bound or at the time of payment, should have known of the securities in the hands of the creditor. Section 924. Rights upon which subrogation operates. The subrogee is, in general, entitled to stand in the shoes of the creditor, and to enforce every right which the creditor himself could have enforced, so far as necessary to secure reimbursement or contribution. This includes the right to enforce the principal obligation itself, even though it be discharged at law, and to claim all of the incidents of such obligation. If it be a preferred specialty debt, the subrogee is usually held entitled to rank as a preferred creditor, and it seems that the period of limitation applicable to the obligation in the hands of the creditor should apply also to an action by the subrogee, although this is not generally recognized. So a provision in a note for liquidated damages, or attorney's fees in case of suit, may be taken advantage of by the subrogee. The subrogee may also claim any collateral securities in the hands of the creditor, whether they be in the form of a mortgage given by the principal debtor, or a lien rising by operation of law, as in the case of a vendor's lien, landlord's lien, or mechanic's lien. He may also claim the advantage of any securities obtained by the creditor through his own efforts, as in the case of an attachment or judgment lien, or the right to finish an uncompleted suit. Miscellaneous rights to which a subrogee has been held entitled are a charge by will on land, rights in an assignment for the benefit of creditors, the right to set aside a fraudulent conveyance, right to follow trust property into the hands of a purchaser with notice, the right of an administrator to reimbursement from land of the estate for debts paid, the peculiar priority of a purchase money mortgage, money reserved by order of court as security for a fiduciary's performance of duty, the machinery of collection, including the right to bring a creditor's bill. A subrogee may be entitled to enforce the creditor's rights against third persons, other than the principal debtor. It extends to rights against a third party liable ex delicto, as a purchaser of converted goods, or one participating in or assisting a breach of trust or other wrong on the part of the subrogee's principal, and in short, against any co-surety, to the extent of proper contribution, and against any other surety or person in the position of a surety, whose liability is prior to that of the subrogee, or from whom the subrogee would be entitled to indemnity. A joint debtor paying a debt in full is also entitled to the benefit of the creditor's claim against all of the other joint debtors. Where the state is the creditor, as a rule, no difference is made in the right of subrogation, and the subrogee is entitled to enforce any lien or preference belonging to the state. This doctrine is limited, however, by some cases, which, apparently, upon grounds of public policy, deny to the individual the peculiar machinery of collection reserved to the state. Section 925. Subrogation of creditor or co-surety to securities given to indemnify a surety. Where securities have been given by the principal to a surety, to indemnify him against loss, the creditor is said to be subrogated to the rights of the surety in the securities. Similarly, a CO surety who has paid part or all of the debt is entitled to the advantage of the securities, equally with the one to whom they were given. These cases depend upon the principle that the securities have been dedicated, as it were, to the payment of the debt, and so a constructive trust for that purpose will be enforced. They belong to a different field of equity jurisdiction. Therefore, from cases of subrogation in general,